Thank you, Mr. Speaker. I rise to speak at report stage on Bill C-38, a bill which many other colleagues in this House have accurately described as an affront to democracy. I heard my honourable colleagues say that somehow we should, in the opposition benches, speak to the content of the bill, and I propose to do so. But I also find that it must be referenced that this is the appropriate role of the Parliament of Canada to review legislation. It is not mere process that gets in the way of the grand aims of the particular Conservative ruling Privy Council. The role of Parliament is, at its essence, to review legislation. In this case, we have before us a bill of over 420 pages, repealing, amending, changing over 70 different laws. We now have before us hundreds of amendments grouped into 159 votes. But we know that this legislation will not receive adequate review. I'm going to direct my comments to those aspects of Part 3 that are changed in Bill C-38, but I note that my amendments cover things that are changed in Part 1 under the Income Tax Act, changed roles that are important for instance, the various agencies that are being ended, like the National Roundtable on Environment and Economy. That does not end up in Part 3, which is generally reviewed as the sort of the environmental changes that are hidden within Bill C-38. There are many changes within this legislation that will have long-term, serious, and negative repercussions for Canada, for Canada's society, and yes, for Canada's economy. It is a false piece of rhetoric. We have to beware, Mr. Speaker. I don't like to be biblical very often, but beware the wages of spin. We're told a lot of spin in this House all the time that this is going to bring great jobs and prosperity. By asserting our rights to examine Bill C-38, we're not threatening the economy. We're trying to protect the integrity of Canadian institutions and our ability to forge policies that protect the environment while developing our resources. So in that light, I want to turn to some of the evidence we did hear. I wasn't a member of the Subcommittee on Finance, but it is at its essence appalling that the repeal of the Canadian Environmental Assessment Act, which has served Canada since 1993, and according to industry sources I've already cited in this House, was working well up until these amendments. We've repealed under C-38 the Environmental Assessment Act and see a whole new act in its place. That new act, on the basis of expert evidence to the Subcommittee on Finance, will not work well. It will not work well for proponents who want to build projects. It will not work well for Canadians who have an interest in the proceedings and wish to come forward and present their concerns. It will definitely not work well in respect of First Nations and their inherent and treaty rights, which the federal government has an obligation, a fiduciary duty, and numerous court decisions which say we must respect those obligations. It will not work well for industry. When you have an entirely new scheme of legislation put forward without adequate review, less than 14 hours of hearings combined on the changes to the Environmental Assessment Act, changes to the Fisheries Act, changes to the Species at Risk Act, changes to the Navigable Waters Protection Act, what they've done is they've taken, and when I say they, Mr. Speaker, I refer to C-38's drafters, and I don't blame those in the legal departments who drafted this, clearly without adequate time, without adequate preparation. They have taken a sledgehammer to environmental law and policy that's served this country well for decades. And that sledgehammer approach has left environmental law and policy in ruins. The amendments that I've put forward today, Mr. Speaker, I hope that the Conservative members of Parliament will look at them and consider voting to support some amendments in order to make C-38 serve the purpose they say themselves they want, to protect the environment while pursuing economic development. In specific cases, Mr. Speaker, the new so-called Canadian Environmental Assessment Act 2012 fails to define what an environmental screening is, fails to describe what an environmental assessment is. They've done so much damage to the scheme of the legislation that they have created new chasms of uncertainty. Anyone who's about to do a project will not be able to tell from reading the new so-called SIA 2012, what it will cover and what it won't. I've heard the honourable members for Wellington, Halton Hills and Dufferin-Caledon numerous times, and I applaud them for it. They have called on the floor of this House for the federal review of the appalling mega quarry proposed for Melancton Township. But if C-38 passes, watch out, don't call for a federal review. It's the last thing you'd want, because the only thing that the Environmental Assessment Panel would be able to look at would be the effect of the mega quarry on fish, marine plants, and migratory birds. The essence of the threat posed by that mega quarry to the water table, to surrounding farms, to the fertility of that soil that is absolutely world-beating. I mean, you can't grow better potatoes than they do in the soils of that area of Melanchthon County. And yet, that mega quarry, if it had a federal assessment, would be restricted to looking at the impact on migratory birds and fish, Mr. Speaker. It is, again, the effect of a sledgehammer. The witness I want to mention, and people can look to his testimony in Hansard, Stephen Hazel, who worked as a member of the legal staff of the Canadian Environmental Assessment Agency, said exactly this. The law will lead, this change will lead to greater uncertainty, more economic losses, and mistakes that will cost us well into the future. The same point was made by National Chief Sean Atleo of the Assembly of First Nations. These changes will lead, in his words, to greater conflict, greater uncertainty, conflicts in the courts, conflicts in terms of direct action. Mr. Speaker, this is not the way we want to go if we're interested in democratic processes that respect all parts of a society when we embark on large new projects. The other pieces I must speak to in the limited time I have, Mr. Speaker, are on my amendments that attempt to repair the damage done by the sledgehammer to the Fisheries Act, and particularly to subsection 35(1). I know that the Minister of Fisheries has addressed this House numerous times, claiming that the municipalities of Canada were clamoring for these changes so that when they put in various municipal works, they don't have to worry about whether there's a habitat for fish in the vicinity. Yet the claim is belied by the emergency resolution vote of hundreds of municipalities representing the Federation of Canadian Municipalities last weekend in Saskatoon, when they passed on an emergency basis a resolution calling upon the Prime Minister to stop, to rethink this, to remove the Fisheries Act changes. In the same tone, we have the words of 4 former fisheries ministers, the Honourable, and I can mention their names in this place because they no longer sit among us, but fine and honourable public servants, former Fisheries Minister Tom Sidden, the Honourable John Fraser, Herb Dhaliwal, and David Anderson. By not just chance, Mr. Speaker, I stand here as the only leader of a federal political party from British Columbia. I note that those 4 former fisheries ministers all hail from British Columbia, where we understand that wild salmon is as important to British Columbians as the French language is to Quebecers. It's part of who we are as British Columbians to defend our salmon. And when we see a change that would allow wholesale destruction of fish habitat that supports sockeye, the wild salmon runs that are endangered, coho, why would we in this place make changes that do such damage to the linchpin of environmental protection in Canada? Section 35(1) of the Fisheries Act just doesn't protect a few fish. It is the fundamental piece of legislation and is part of federal jurisdiction in the Constitution that leads to the protection of fresh water. It leads to protection of grizzly habitat. It protects forests. It protects ecosystems. And without Section 35(1) in the Fisheries Act intact, we open up the gangway to reckless destruction of our extraordinary natural resources, but of nature itself. Mr. Speaker, we're constantly being told that we have a false choice, that we have to choose between hell-bent for leather economic development with no attention to what it means to First Nations rights, no attention to what it means to sustainability of natural capital. We're told, as I mentioned this House before, Mr. Speaker, that the planet is a business in liquidation and everything must go as quickly as possible and as fast as possible. Please, I beg of my Conservative colleagues in this place, reflect on the voices of your former colleagues, people like the former Member of Parliament for Red Deer, Bob Mills, who's pleaded that we keep the National Roundtable, people like these former fisheries ministers, scientists right across Canada. Mr. Speaker, now is the time at report stage to rescue C-38 from being a bill that destroys the environment long term to one that respects it. Thank you, Mr. Speaker.